In this presentation, we will talk about judicial procedure and judicial process. At the end of this, we will be able to explain the federal court system in America, describe the kind of cases that can be heard by the U.S. Supreme Court, explain the state court system in general, describe civil litigation. We'll also discuss what an appeal is and what the process is for appeal, and we'll discuss the steps for the criminal prosecution within a legal system. Within the United States, laws are interpreted by the court system. So the legal system is going to be comprised of a system of courts, the courts being in the process of interpreting the law that is created by the legislation. The courts then are going to be a place where there are going to be regular meetings in an attempt to weigh out disputes that are going to be happening between two parties in a way that is applying the current legal system. When thinking about this system, we can see that it is an argumentative type of system, meaning we're typically going to have two individuals or two groups that are going to have some type of dispute that they disagree about, and then go to a third party, supposedly a neutral party, the court system, which will apply a set of principles and hear the arguments from the pros and cons from both sides. And through hearing an argument in both sides, the court system can then apply the legal precedents or the legal system or their review of the case based on that information and come to a decision, a conclusion for it. As we've talked about before, we do know that this is going to be applicable in terms of the actual laws, the words of the law that can be applied in some cases, but oftentimes there's also going to be some interpretation of the law that is going to have to be put into place as the cases will differ, and precedent will take case as well in terms of looking at prior cases and seeing how the law has been applied in similar cases when making decisions within a court system. Article 3 of the U.S. Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Therefore, the federal court system the authorization is being authorized through the Constitution. Now, currently, the court system is including the Supreme Court, the courts of appeal, and the federal district courts. As we get into the more complexity of the court system, we can see that there will be overlap within the court system, and we have the question as to which court should hear which case. And that's going to get into the question of jurisdiction, meaning which court has the ability to hear which case, who should be hearing the case of a particular court. We have the original jurisdiction, and that is typically going to be the original court which the case is brought to. Then after we go to the original court, we may have an appellate court or an appeal process that would be then conducted by the appellate court. The appellate court typically has the authority to reverse the ruling of the original case if the circumstances subscribe that it do so. If a court has the jurisdiction to hear any type of case, we would say that that court is a general jurisdiction. We have general jurisdiction. We're going to have some courts, however, that have special jurisdiction, have jurisdiction over a particular area. For example, probate courts will have a special jurisdiction. Each territory and state within the United States will have at least one U.S. District Court, otherwise known as Federal District Court. The Federal District Court have subject matter jurisdiction over cases that could involve federal questions. Questions such as, for example, questions related to the constitutionality of a particular case, whether it complies with the Constitution, with the law of the land. When no federal law is involved, the federal district courts could still be involved when there's going to be an issue, for example, between citizens of different states. That could be an issue where the federal district court would be in place. This, of course, being a place where there's some overlap between state laws that could differ from state to state. The U.S. Court of Appeals can overturn decisions of lower courts, but must follow the standards of review process. The three standards of review are plenary, clearly erroneous, or abuse of discretion. The U.S. Courts of Appeals can hear appeals from the U.S. Tax Court, district courts, and other administrative agencies. So the idea there being that we can take these process to the appellate courts in order to appeal the original decisions. However, it has to go through a standardized process in order to go through the appellate court, and the appellate court needs to go through the process in order to decide whether or not the courts that made the original decision can be overturned given that process. There are currently 13 U.S. courts of appeal in the federal court system. The U.S. Supreme Court is the final court that can be appealed to. In other words, if a case goes to lower courts and it's going through the appeal process, the final court that can be appealed to would be the U.S. Supreme Court. The U.S. Supreme Court can have original jurisdiction, however, in some cases. In other words, it's not just the case where it's going to be the final review process for an appeal process of a case, but can have the original case taken to the court. For example, if there's an issue between states where a state itself is going to be a party, then that's going to be an example where the Supreme Court, it can go there first as the original jurisdiction for that case to the Supreme Court. The U.S. Supreme Court is comprised of a Chief Justice and 8 Associate Justices. They are appointed by the President and approved by the Senate. The way a case often gets to the Supreme Court is by request. So the Supreme Court will typically have a request in order to review a process. This typically done with a writ of certiorari. A writ of certiorari is going to be given to the lower courts in order to provide a request for the Supreme Court to review a particular case. If we think about the court system as a hierarchy, we will of course have the United States Supreme Court at the top of the hierarchy. And then we've got the appellate courts that would appeal if we appealed from the appellate courts to the United States Supreme Court. So we've got the U.S. appellate courts and the appeals process for the federal circuit courts. And then we've got the lower courts that would then be the original jurisdiction courts for many types of cases that then would go to the appellate courts within a review process. And if it was to be appealed again, it would then go to the U.S. Supreme Court. So those courts would be courts such as the U.S. Tax Court, district courts, administrative agencies, other times U.S. Claims Courts, U.S. Court of International Trade. Those type of courts are going to be courts that are lower courts where they would have original jurisdiction. If the appeal process was to take place, then they would appeal then to the appellate courts or the U.S. Courts of Appeals. And then, of course, if it was to go through the review process again, we would go to the United States Supreme Court. Now, the state court system is going to have a similar process, of course, and they're going to have a state Supreme Court system and have a similar type of hierarchy, although it can differ from state to state. But we will have the state Supreme Court within the state, and then we can have the courts of general jurisdiction within the state that then would go to the state appellate courts, and then that could go then to the state Supreme Court. And we know that then if there's a process within the state, if the state Supreme Court is having an issue on the appellate, then it can go to the United States Supreme Court within that hierarchical process as well. Cases would typically stop at the state Supreme Court system as they go through the state court system. Once they go to the courts of general jurisdiction and then go to the state intermediate appellate courts and then to the state Supreme Court, that would typically be where most cases would then stop unless there's an issue with something like constitutionality, in which case it could then go to the Supreme Court. So there are going to be, of course, rules in terms of when we can apply the appeals process, when it would go through the appeals process, and how that process would take place within the hierarchy of the courts system. A civil procedure or a civil lawsuit is going to be the case where one party is going to take action against another party in order to enforce a law. The typical goal of that would be some form of compensation, and usually that would be in the form of money, compensating for an action or a wrong done. Both individuals and organizations, for example, corporations, can be the people bringing the suit, the civil lawsuit, or be the defendant within a civil lawsuit. When going through the court process for the civil litigation, we typically will name the individuals involved as the plaintiff and the defendant. The plaintiff is going to be the one that brings about the lawsuit, and they're going to file the appropriate paperwork with the trial court that will have the general jurisdiction, the original case to be heard at it, that being the general jurisdiction. Then we'll have the defendant is a person that is having the lawsuit brought against them in the civil litigation case. They, of course, are going to be the party, the individual, the defendant that people are seeking some type of recovery from oftentimes in terms of money for damages or recovery in the civil litigation case. When filing a complaint, we're going to need some basic facts, of course, of the complaint in order to go through the process of the filing process. We're going to need to know who the plaintiff is, who's giving the complaint, and who the defendant is, who's the person that the alleged law breaking took place. So we're going to have to know the facts of the case, and of course that would be given in terms of the plaintiff's facts because they're the ones that will be filing the complaint. And we want to talk about what the violations are going to be, what are the legal violations, how was a legal process or a legal law broken through this, the injuries. We want to see what is going to be a list of injuries from the plaintiff's perspective, from the breaking of the law, and then the requests for compensation, the requests for the relief for the violation that caused injury to the plaintiff. A typical lawsuit will have two parties involved, the plaintiff and the defendant, but there are situations in which the legal costs of bringing the problem to light, the breaking of the law to light, would not be sufficient in order to go through the legal process to get the settlement of a particular case. There are cases where if there's a lot of problem, the law breaking affects a bunch of individuals, but not in a significant way where an individual lawsuit by them would be cost effective or something for them to do, which would make sense logically in terms of the compensation it would receive for bringing the case. And that's really the idea behind the class action lawsuit, where a class action lawsuit is a lawsuit in which the potential plaintiffs file a lawsuit on behalf of an entire class. And thereby we're able to have a bunch of people get together and say, well, there's this problem that's happening, this breaking of the law that's causing a lot of people some harm, some damage. And the logic to bring some case like that would be that the individuals themselves wouldn't be cost effective. It doesn't make sense for them to go through the legal process in order to file the complaint, but it does make sense for them. There is a harm being done, and we can see that pervasively through this group of people, and therefore the class action lawsuit would be something reasonable to file a lawsuit on behalf of this group of people. Class action lawsuits make sense from that perspective because we can typically see, we can see situations in which there's going to be a small effect, a negative effect on a lot of people, and we can define that particular class and we can have representation for that class. But we can also see how class action lawsuits can form abuse. We can see that there is incentive, of course, if we don't have to pay or go through the legal process to want to be in a class action lawsuit, because we really only have gain to get if the class action lawsuit is won, and there's not really any loss in that we're not having to go through the legal process in a similar way if we were having to bring the case to court ourselves and go through that legal process. And therefore, there may be more incentives in a class action lawsuit for individuals to want to be in a class action lawsuit or participate in a class action lawsuit and possibly cause or lead to more abuse within that system. So there's pros and cons to the idea and the concept of a class action lawsuit. One, it's able to look at these specific areas where there's going to be these problems that are affecting a lot of people, but not to the degree that any one of them would really need to go to court, because the gains would not, it wouldn't make sense from the gains of the court case, what they would receive to the time and effort and compensation they would get, possibly. But we can see that as a whole, it would be a good thing. On the other hand, of course, the incentives, if we look at the incentives, may incentivize more people to participate in class action lawsuits given the fact that the gain from a win would be something, and the loss, if there was a loss, would be very little time for many involved in the class action process. A civil procedure typically goes through some stages, and we can lay out some of these stages as: first, the service of process. That's going to be the original complaint being made to the appropriate court. And then we have the pre-answer stage, and this is going to be the concept that once the defendant has been served, they're going to have 20 to 30 days to file an answer to that. And so, of course, we're going to have this process, this pre-answer stage, as we wait for that 20 to 30 day period. At some point, then, we're going to have the answer, which we can then say, well, that's going to be the answer stage, where the defendant has the official response to a complaint that has been made after being served. In the answer, the defendant either must admit or deny the allegations of the complaint. After this stage, we could go to the pre-trial stage, and that, of course, is just when we're waiting for this case to go to the trial stage. And during the waiting period, we could do some information through that process as we wait for the pretrial stage, and that could include things like the pretrial conference. We could have discovery and filing of pretrial motions. A pretrial conference could have parties get together and see if they could settle the case without a court trial, and they also can lay out the details involved within the case. There are also several motions that can be filed during this stage, this pretrial stage. For example, a summary judgment could be filed. That's going to be a motion to the court for immediate judgment for the party filing the motion. It's just an example of motions that can be filed during this process as we're waiting for the court case. And then, of course, the process of discovery is the process where the parties of a civil action search for information that is relevant to the case. So as we're waiting for the case, then, of course, we're going to go through that process of discovery. We're looking for that information that will be relevant to the potential case that will be discussed. Discovery tools can include depositions, requests for evidence, requests for physical or mental examination, requests for admissions. When having a jury trial, the process will first start off with selecting the jury for the trial. When we have the trial, we're going to start off with the opening statements, each of the defendant and the plaintiff having the opportunity to present the opening statements. And then we're going to go to the plaintiff's case. So we'll start off with the plaintiff's case with the plaintiff's case in chief, that giving the opportunity for the plaintiff to give evidence to back up their story. This could include witnesses. Those witnesses could have direct examination, the direct examination typically being the process of asking questions in order to support the case being made by the plaintiff. And then, of course, cross-examination being answering questions from the witness by the defendant's attorney, often the idea being to have supporting evidence or reduce the likelihood of the story for the defendant's opportunity in that process. Then we've got the defendant's case in chief, where the defendant has the opportunity to present evidence to support their innocence or their argument. And they, of course, can go through a similar process and call witnesses for the same direct examination. And then that direct examination would be the process of question them in order to support the defendant's case, and then the plaintiff's attorney would have the opportunity for that cross-examination with the similar goal, this time to distort the story or to see that the story was untrue or to present evidence that would be of support for the plaintiff's case. Once the cases have been presented for the plaintiff and defendant, we go through the rebuttal process. And that'll be the opportunity for the lawyers to discredit the other side's case and to further strengthen their own case. We call this the rebuttal process. Sometimes it's called the surrebuttal when referring to the defendant's rebuttal. So when we talk about the defendant's rebuttal process, it can be called in some states the surrebuttal. We then move to the closing statements, each attorney then having the opportunity to make closing statements. The goal here being to summarize by each attorney those points within the case which they think are most persuasive to the outcome they would like. We then often go through the process of instructions for the jury, and then finally we're going to have the verdict or judgment on the case. Once a court case has been completed, it could go through an appeal process at that point in time. The appeal process basically being a referral to a higher court for a review of the process. There has to be some reason, some grounds for that appeal process, and there's got to be some kind of legal reason for the appeal process. For example, if evidence was presented that should not have been presented for the case, or some other legal processing item happened which should not have happened, that may be an example of grounds for an appeal process. Criminal procedures and criminal prosecution is a bit different in that the goal here is not just to compensate one individual who has been wronged by another through an illegal act, but in this case, the criminal prosecution would be there in order to help society out in some way by keeping society safe, by either arresting or penalizing criminal behavior to reduce criminal behavior to be happening, or to take people out of society who are exhibiting criminal behavior that can be of a threat to others involved. The steps in a criminal prosecution will typically be first the arrest, then the preliminary hearing, then formal charges, and then we're going to have the arraignment, finally followed by a trial. For more accounting information and accounting courses, visit our website at accountinginstruction.info.